practitioner who is prepared to provide an opinion. There is, of course, no obligation as to what that opinion must or should contain. And then the second element is the performing of terminations of pregnancy itself. And in relation to that, I say that any registered medical practitioner or any registered nurse or midwife who has a conscientious objection to the participation in the performance of a termination of pregnancy should be entitled to refuse. Now, I don't provide an obligation in the bill to refer the person on, but I note the comments of Professor Kieran Murphy of the Irish Medical Council on his and the Irish Medical Council's view on the question of conscientious objection. And also, conscientious objection will not operate to allow a registered medical practitioner or a registered nurse or midwife to refuse to participate in treatment that would be necessary to save the life of a pregnant woman. And this is the last thing to deal with, is the question of lethal fetal abnormality. It flows from what I've already said about what we can reasonably infer, that I row in behind Ms. Schwepp and Ms. Staunton on the question of lethal fetal abnormality. Where there is no capacity to be born alive, then Article 43.3 does not confer a constitutional right to life. It doesn't lessen the moral seriousness of a termination. It doesn't lessen the values we may hold about the question of termination. But what it does tell us, what the Supreme Court has told us, is that such fetuses or embryos do not attract protection under 43.3, and as such, a bill that provided for the termination of an inevitable miscarriage of a non-viable pregnancy, or that provided for termination in the case of such scenarios of lethal fetal abnormality, would be permissible, in my view, under Article 43.3.
Thank you. Senator Burke.
Thank you very much, Chairperson, and thanks to our panel for giving a very comprehensive overview here this morning. Could I just touch on one or two things that were referred to yesterday from the Institute of Obs and Gynae? In the expert report group, they gave a number of different choices about who should make the decision in relation to the area of suicide. They gave the option of 2 specialists plus, and then it's referred on to an obstetrician specialist plus an obstetrician, or 2 specialists, 2 psychiatrists plus an obstetrician. The Institute of Obs and Gynae suggested that in fact it should be 2 obstetricians. And the question I have is in relation to, in deciding the issue of suicide, do the panel feel that 2 obstetricians can make a decision on the issue of suicide when their expertise is in the area of obstetrics and gynecology and not in the area of psychiatry? And I know that they were talking then that they would refer to a psychiatrist also being involved. But, you know, there's a panel of 3 which they were referring to in that case, and I'm just wondering about the legal aspects of that. That's one question. The second issue is in relation to Section 8 of the draft bill provided here this morning, and that's in relation to 2 medical practitioners having to sign off in relation to a miscarriage. And it's just in relation to the evidence given to us yesterday, where in the smaller units, where there's only 1 consultant on from 5 o'clock on a Friday evening till 9 o'clock on a Monday morning. And I'm just wondering, Section 8, I don't think is operational in that situation. Maybe you might like to come back to me on that one. It's just a concern I have. And finally, on the issue of fetal abnormality, it's a very fine line as regards deciding whether a fetus would survive, baby would survive for 1 second or 10 seconds after being born, and deciding it at, say, 4 or 5 months of pregnancy. I'm just wondering the legal complications in that decision being arrived at. How do you put a formula in place to deal with that? I'm not too sure if the legislation or the draft here deals with that issue. Thanks.
Thank you, Deputy Dowds.
Thank you, Chair, and could I welcome our visitors, and thank you for your input. One of the things that the medical experts cried out for yesterday was clarity in the law in terms of them treating a woman where they felt a termination was required. And one of the points that was particularly made by the Master of Holles Street, if I remember correctly, was that it's really impossible in many circumstances to know exactly the extent to which a woman's life is at risk when they have to intervene. And they cried out for legislation so as to protect them in their work. And my question to you is this: within the constitutional constraints within which we operate at the moment, will it be possible to draft legislation that would actually deal adequately with the situation that they want rectified? Thank you.
Thank you, Deputy. Senator Ginny Van Turnhout.
Thank you very much, and thank you to our three witnesses. My understanding is that nobody disagrees with the repealing of sections 58 and 59 of the Offences Against the Person Act, and I just want to confirm that. Yesterday we had considerable discussion, as has been in the media, about suicidal ideation or suicidal intent. And certainly from listening yesterday and considering it overnight and looking again at the Supreme Court judgment, I don't see a necessity for us to have a different procedure to determine whether or not a woman has a right to access an abortion where the risk to her life arises from the matter of mental rather than physical health. And the substantive weight should actually be given to clinical determination involving the practitioners with relevant specialisms involved. And I just want your guidance, because I think we've separated an issue that, from reading, actually I wonder why it has been separated, so I'd welcome your guidance. In regard to time limits, I was very reassured by the medical opinion yesterday, and also if you look at the Supreme Court interpretation of 40.33 as well as the wording in it itself, and having reflected on it, the lack of such a time limit is actually mitigated by the strictness of the test itself. And that's my understanding, and I would very much welcome any guidance you have. And I do welcome the guidance you've given us on fetal abnormalities, so I won't go into that issue. And I also welcome on the issue of consent, and I've actually read the Law Reform Commission report, which is quite weighty and quite detailed and does give options. And I do think there are still issues for us with regard to children in care, but also children in care of the state, because these different legal limbos we have are unaccompanied minors. And I think these are the issues that perhaps we'll have to tease out as a committee.
Thank you. Deputy Dennis Naughton.
Thank you, Chairman. A couple of questions. First of all, to Dr. Mills. Could I ask you, maybe just putting on your medical hat for a second, and you made the point that you have dealt with a number of cases of women who were who required or went for a termination. Can I ask you, did you come across cases of women with suicidal intent during your professional career? Secondly, if I can ask you, you made the point in your last contribution regarding fetal abnormalities, regarding babies that are born to suffer and die, even if it's only for a number of seconds. But is it not the case that, and from the evidence we had here yesterday, that the vast majority of terminations will be terminations by induction to lead to a premature birth? And in those cases, would there not be suffering involved? And if there's medical intervention, would there not be suffering involved? The final question I have is for Ciara Staunton, and it's in relation to the issue of suicide and your suicide test, and you make the point regarding a pregnancy due to rape or incest, that suicidal risk can only be averted by the termination of the pregnancy. In that case, and you're saying that there shouldn't be a termination date beyond which an intervention would take place, what would happen in a situation where you had a woman in that particular circumstance where the child was actually born and was viable beyond the 23 weeks? Would we not need to have to put some legal clarity in place regarding the guardianship of that particular child who wouldn't have been wanted by the mother, who wanted a termination? How do we deal with that legal challenge? Just very finally, Colin Burke raised the issue of suicide. The perinatal consultants here before us yesterday said that they believe that 2 psychiatrists should sign off in relation to the issue of suicide. What's your opinion in relation to that?
Thank you very much.
Thank you.
Senator John Crone.
Graham Algott, I'd like to thank you for coming in, and I must say these are really very clear and informative presentations. I think there are 2 interrelated issues which cannot be seen in the absence of a context of our health service, and that's the necessity for the provision for perhaps short-cutting of the approval process for a termination when an emergency arises, and the question of conscientious objection, because they both seem to presuppose the notion that we have some resemblance of a normal health system in this country with the uniform number of large, well-staffed, comprehensively staffed units with lots of consultants around. That is not what we have here. We have a large number of units which do not have that level of staffing, and these specific circumstances need to be taken into account. I must say I was very, very taken by Simon's presentation with respect to the moderate position, because it's one I've been espousing myself for some time. And there's little doubt in my mind that the core problem and the core reason why the abortion debate paralyzes public policy, jurisprudence, Supreme Court appointments in the United States, elections, and so much is because of a failure of our profession, the medical profession, to come down off the fence and to make a stab at defining when personhood as opposed to life begins. People are quite happy to let doctors decide when life ends. They're quite happy to take a body with a beating heart, with an oxygenating, ventilatory system with the aid of artificial respiration, be deemed to be dead because its brain is no longer sensate, conscious, and working. And we need to get to the other side of that debate at the earlier side of the argument. But the relevance is, with respect to your question about lethal fetal abnormalities, and I think you're wrong. And the reason I think you're wrong is that I think the wording of the constitutional amendment, as currently read, seems to guarantee the right to life of the existing child, not the right to a future potential life which begins at the time of birth. And I think it would be extremely difficult, and my guess is we're going to get legal opinions which will be somewhat respectfully contrary to yours on this, that there will be a necessity for a constitutional amendment if we are specifically to legislate on the issue of inevitable fatality as a result of fetal abnormality. But thank you very much for your presentations.
Thank you. We have 20 minutes remaining now for replies and other questions from members if it's available. So maybe Ms. Donlan, you might start this time, maybe.
Okay, I will just start first of all with Deputy Nocturne, who spoke there about a viable child. The test is a woman is entitled to a lawful abortion if there's a real and substantial risk to the life of the woman which is due to that pregnancy. It's irrespective if it's due to a mental health issue or a medical issue, she is entitled to that termination of pregnancy. Now, if there is a viable child, just say, for example, she's at such an advanced stage where the child is viable, the doctor first must save the life of the woman by terminating that pregnancy, and then they should do everything they can to save that child. The issue of guardianship is absolutely nothing to do with what we're talking about right now. There are structures in place to deal with a child if a mother wishes to give her child up for adoption, but that has absolutely nothing to do with what we're dealing here now. Just get my notes. Deputy Van Turbot, yes, I do agree to repeal Section 58 and 59, but replace. You can't just repeal, you must replace it. And with your suicide intent, yes, there's absolutely no difference. The only reason why I've separated it out is because there's been such a discussion that it will really it will give rise to floodgates, but it simply will not happen. It's just too narrow of a test which we have. There are very few cases which we are dealing with, but they should be dealt with together. Sorry, Deputy Dow, what was your question again?
It was in relation to one of the things that the medical experts were saying yesterday was they needed legislation that would give them support, and they couldn't always be sure the extent to which a woman's life would be at risk. Is it possible to produce legislation within the constitutional restraints that we have at present?
Absolutely, and the reason why I would say that is because we are not dealing with cases of beyond a reasonable doubt. We're dealing with on the balance of probability. There is a real and substantial risk at some point during the pregnancy. So if a doctor believes that a woman who is 2 months pregnant, she will have a real and substantial risk on the balance of probability in their clinical judgment, and it's exceptionally important that we do acknowledge in this legislation the importance of in clinical judgment. But they believe even at 8 months, 9 months, that her life is at risk, she is entitled to a lawful abortion. I think that at the moment doctors aren't sure if it's on the balance of probability or if it has to be proved beyond a reasonable doubt, because it's just so much uncertainty, and the threat of criminal prosecution in Section 58 and 59 adds to that fear and uncertainty. So yes, I think once it's clearly stated on balance of probability, a real and substantial risk to the life of the woman at some point during that pregnancy, she's entitled to a lawful abortion. And I'm sure Dr. Mills can echo this, that I think doctors would feel more comfortable with a test like that.
Sorry, you're in already.
A year after the birth,
Sorry.
for example.
The issue of time limits, sorry, I can't remember who spoke about this. Senator Van Turbot. I don't agree with the insertion of time limits. Time limits usually actually arise when we are dealing with abortion on demand, which we are clearly not dealing with here. We're dealing with a very small number of cases in which a woman's life is threatened, and we should not have any arbitrary figure in there. A doctor will know whether or not he can save the life of the woman and vindicate the rights to life of the unborn, as well as cases arise and in accordance with their clinical judgment.
Thank you. Okay, Dr. Mills.
Just to deal with of viability and time limits, first of all, I agree with Ms Staunton that the strict construction of Article 43.3 as interpreted in the X case does not include time limits, but I can also see that in terms of drafting legislation that would attract general support and still not be unconstitutional, there might be certain types of termination not expressly covered by the X scenario for which time limits might be appropriate. I'm going to put it any further than that. It's something that's really just almost germinating in my head as I've been sitting here having this very helpful discussion and bearing in mind the conversations, the submissions that have been made by Ms Schwepp and Ms Staunton. It's something I'd be happy to return to in any future discussions of the draft bill. Just to deal with the other issue that Senator Van Turnhout mentioned was the question of treating suicide differently. I largely agree with what Ms Staunton has said, which is that as a matter of broad principle, there is absolutely no distinction to be drawn between a threat to the woman's life by reason of the continuation of her pregnancy as a medical matter or as a psychiatric matter. However, there are two distinctions that I do think need to be drawn, and it's one of the reasons why I treat it separately in the draft bill. The first is that the required specialisation of the doctors making the assessment must necessarily be different. And I think somebody touched on this earlier on. Do we want obstetricians deciding on the psychiatric well-being of women? No, we don't, obviously. Any more than we want neurosurgeons deciding on the viability of pregnancy. So that's the way that one would deal with that. One has different and appropriate experts. The other way in which one might treat it differently, and I offer it tentatively again in the draft bill, goes to the difficulties in suicidality that have been identified across witnesses, which is that its presence or absence may be fluctuant. It may be there one day, may not be there another day. And I do tentatively suggest in the draft bill that as distinct from scenarios of medical emergency or medical crisis, it may be appropriate that assessments for suicidality would be carried out on two separate dates. Also, just flowing from that, in reply to the question about rural hospitals where there may only be one doctor, this in a sense bleeds into what Senator Crown was saying earlier on. If we assume that the opinion of two doctors is generally preferable to the opinion of one, should we put women who are in rural locations or in poorly resourced hospitals in effect at a disadvantage? And it may well be that in drafting the issue of a serious and immediate threat to life, that one may have to reflect on the question of the number of experts who would give an opinion in circumstances where, for example, there is only one expert available, and in the view of that expert, a termination within the meaning of any available legislation is necessary. And provision could be made by way of regulation in the reporting of any termination or in the certification of any termination for an expert to explain the reasons why a second opinion could not be obtained, although it would normally be required under the Act. That's one possibility. And then there was a more general question about the need for clarity. Would this provide the kind of clarity that doctors work? And I would say to the Deputy, have a read of the bill that I provided to you. And I hope that it shows that a clear, workable, sane and sensible legislation which will guide doctors in a way that they can live with is not an unachievable norm. Doctors make life and death decisions every day. The last question I think I was asked was, and I think it's quite an important question, I think it was Deputy Naughton who asked me this question, well, is there a difference between a fetus with a lethal abnormality who will suffer by reason of being born, and a fetus, for example, who is delivered prematurely and must suffer as part of being delivered prematurely. And yes, there's an obvious difference. It's an obvious moral difference, and to my mind, it's an obvious legal difference. The fetus born with a lethal fetal abnormality is being born solely to die. The fetus who is delivered prematurely with a view to effecting its survival is being born to a wholly different purpose. And it seems to me to be a logical moral distinction. And just to deal with the last point raised by Senator Crown and his disagreement on the meaning of Article 43.3, I hope it's clear to the committee, and just to reiterate for Senator Crown, this is not the three of us forming our view of Article 43.3. It is the three of us articulating the view of Article 43.3 that was formed by the Chief Justice in the case of Roach.
Thank you. Schwab.
Thank you. I just have one or two issues that I want to comment on. First of all, I totally agree with Simon in relation to, or sorry, with Dr. Mills rather, in relation to the link between suicide and termination, that it should be individuals who are qualified to make these decisions that make the decision, that is, psychiatrists. Again, what's important to note in relation to any termination of pregnancy which is permissible under the Constitution, according to the X case, what we're talking about is a matter of probability. So there does not need to be any certainty, Deputy Dowds, in relation to the risk of a medical, be it a psychiatric or physical risk, or in relation to the fatal fetal abnormality issue. I think the matter of probability test is one which should determine this, and I agree with Ms Staunton on that. I don't think that there should be any different procedure aside from who determines the risk in relation to suicide. I think to do so would be to bring us back to a situation where we're stigmatising mental health. I thought we had moved on from that, and I think that to treat them totally separately would bring us as a country back a step. In relation to consent, Senator Van Turnhout, I think the parallel legislation probably would be suitable here, not just to deal with young people, but to deal with anyone for whom a proxy consent is required, wards of court, people who are vulnerable, and so on. And I agree with Dr. Mills' assessment of our collective opinion in relation to the definition of life, Senator Crown. We're just articulating the law on this issue, as opposed to maybe a philosophical or moral position. Obviously, the reason we're here is because there is no definite agreement on what the law is. Lawyers would be very poor if we all generally, collectively agreed on what the law was. But what we're doing is articulating what Justice Denham said in the Roach case, and we think that that applies here.
Thank you. Deputy Mayor Mitchell O'Connor, and Senator Burke, you indicated it.
Thank you, and thank you very much for your presentation. And I suppose if I could ask Dr. Mills, please, you know, I've gone through your bill, or your proposed draft bill, and what I'd like you to, if you could clarify for this committee and also for the audience out there that are listening in, can you guarantee that the floodgates will not be opened if this bill, as you have put together, you know, will it allow the floodgates to open, that people or that women can go and get abortions because of giving, and what I hear out in the public, of giving an excuse that they want an abortion because of suicide? And I think that's a huge argument in the general public. They feel that once we put in some legislation, it will open the floodgates, and even if we don't do it in the first year, that they'll go to the courts, and then they'll be able to do it 2 or 3 years down the line. And I think that's the real worry out there. And if you could kind of nail that for me, please, I'd be very appreciative.
Thank you. And Senator Burke, you were already very briefly, because we've got 8 minutes in this session.
Just I want to come back on the issue which the Institute raised yesterday, the Institute of Obs and Gynae. They were saying they wanted 2 obstetricians and 1 specialist on the issue of suicide. I'm asking, is that workable? Because I don't think that's been clarified, and I just want clarification on that, because it goes outside the expert report group recommendations.
Thank you. Okay, Dr. Mills, and then...
Well, to deal with the second question first.
We have 7 minutes remaining in this slot now.
To deal with the second question first, I think that's a matter of nuance to some extent. The question of how the practicalities of it would work is clearly a matter to be worked out. Ultimately, Could I say that I'm wedded to the idea of 2 experts if there is a significant body of opinion that says 3 experts? There may well be cases where 3 experts are appropriate. But I think to some extent it's an intellectual cul-de-sac. And I think it tells us nothing about whether or not we can formulate legislation that is workable. Of course it's workable. It's more workable in large teaching hospitals where there are plethoras of specialists and subspecialists and super specialists than it may be in rural hospitals. And again, it may go back to what I was saying earlier on in reply to the other question about how do we manage this scenario in context of limited resources. In relation to Deputy Mitchell O'Connor's report or question, I have been through this bill, as you can imagine, in some detail. I offer it with some trepidation because one does not want to put one's head above the parapet only to have it shot at. I have discussed the bill with a large number of professional colleagues, and not one of them has identified a loophole in the bill that would tend to suggest that it would in any way open any floodgates. The parameters in it, and I'm very grateful to you for having read it and taken the time to consider it. The parameters in it should be very clear. They are very tightly drafted. And in my view, I don't see any provision through which some tricky lawyer will drive a coach and horses in order to usher in abortion demand. And that is the height of the position as I can put it.
Sure.
Yeah, very, very quickly, I agree with Dr. Mills in relation to the practitioners who make this assessment. I agree with his position on that. You know, you could say, why not, if 2, why not 3, if 3, why not 4, if 4, why not a committee? 2 is workable, it can be done quickly, and where we're talking about a real and substantial risk to the life of the pregnant woman, I think expediency is required here. I have read Dr. Mills's bill. I don't think it's possible to drive anything through it, not to mind a horse or a coach. We can't guarantee floodgates can't be opened. Nothing is guaranteed in law. What we can guarantee is that we're not doing anything with the Constitution, and the Constitution obliges medical practitioners, everyone in society, politicians, to respect and vindicate the right to life of the unborn. Yes, we do need to give due regard to the right to life of the pregnant woman, but there is nothing in any legislation which can affect that right to life of the unborn, and we need to accept that. To say that medical practitioners will start terminating pregnancies in a more general way, I think, is to diminish the profession, and I think that we need to respect the fact that medical practitioners will act in accordance with the legislation and the guidelines.
Thank you, Ms. Staunton.
Very briefly, just on the point that Deputy O'Connor raised, like Ms. Trepp said, we can't guarantee floodgates. However, what we can guarantee is that if the legislation is drafted correctly in accordance with X, reflecting Article 43.3, the floodgates should not be open. The risk of suicide, which arises from a threat from the pregnancy, is the only time in which you can have a lawful abortion. And to suggest that women would be going around giving an excuse, I think it's insulting not only to pregnant women but also to the medical profession, because it suggests that they cannot distinguish between giving an excuse and an actually suicidal woman. So while we can't guarantee, I would be very, very surprised. We are not dealing with abortion on demand. We're dealing with a very, very, very narrow set of facts in which abortion is lawful in this jurisdiction.
Thank you. Deputy Minister O'Connor, you indicated? Okay. Okay. Any other member offering? Deputy Byrne, yeah. You've got 2 minutes now, very briefly.
Clarification, because I was a little confused.
Sure.
Okay. And it's SWEP, is it? Yeah. Just when you said in number 9 here about for value natural appropriate language, when you said about having regarding in the legislation pregnant women and unborn in that section there. Just ask you a question, and it might seem very irrelevant to what we're speaking about at the moment, but I've listened with great interest to what you've all said, because I'm not a legal mind and I'm not a doctor. I'm a housewife who became a politician. But my interpretation, listen, reading this, I don't know any woman pregnant who doesn't say, I'm having a baby. I don't know anybody who doesn't approach her and say, you're expecting a baby. In your opinion, as legal representatives here, can you answer this question for me? When, in your opinion, is a baby a baby? Is it before birth or after birth? Because I'm still confused in what you've been saying about the fetus and that. And if you could clarify that for me, it would be of great help. Thanks.
Thank you, Deputy. Ms. Swepp.
No problem. I am
minutes.
actually expecting a baby. What's inside my body is unborn. It is a fetus. It is not a baby. Babies are born and you expect the baby to come out of you. And once it does, then it is a baby. I'm also not a mother. I don't have any other children. Therefore, I am a pregnant woman. And I think that when we talk about, when we use very emotive language like mother and baby, that automatically colours the way that we think about this issue. So that's why I say that we should use value-neutral language.
Okay, thank you. Okay, thank you. As no other members indicating, I'm going to move to the 20-minute slot for non-members of the committee, and there are 4 people who have indicated. Beginning with Senator Bacic, you have 2 minutes.
Thank you, Chair. Thanks for the excellent presentations. I would agree with the legal analysis offered. I do agree also with Dr. Mills's characterisation of the debate as three-sided. It's useful to note that research on the views of women who've had abortions themselves, by Fletcher, for example, in Ireland, show they feel disengaged and alienated from a debate that's unduly polarised. It's notable that in these hearings we haven't heard from GPs as a body, nor indeed from women who've identified themselves as having had abortions, and their voices have been absent largely from a lot of this debate. In terms of the legislation, very helpful to have the template. Thank you for that. Should there be provisions?
A number of other people speaking, and I'm just finding it slightly difficult to hear from Senator Bacic.
If members could respect the person speaking and the witnesses, I would appreciate it. Thank you.
Thank you. Specific question, Dr. Mills, and indeed the others. Should there be provision for emergency situations? And where it's a non-emergency, and I know the expert group say at page 36, 1 doctor should be enough in an emergency. Where it's a non-emergency, why do we need 3 opinions? Does that not render the European Court of Human Rights judgment ineffective? Because they point out that paragraph 267 in the ABC case, the need for accessible and effective procedures to vindicate the right to legal abortion. And finally, I would agree with you, with all of your analysis on fatal fetal abnormality. Indeed, the Chief Justice in the Roach case says it, but also in the DV Ireland case, to which you've referred in 2005, the Irish government itself argued that there was at the very least a very strongly tenable argument that where there was no prospect of fetal life beyond the womb, that there was no unborn right to life to be vindicated. And indeed, in June, a number of Labour TDs and senators, including myself, sent a legal opinion to the Minister for Health, Minister Riley, asking that fatal fetal abnormality or lethal fetal abnormality would be included in any legislation, as it would not necessitate any constitutional referendum. So I'm glad to hear your assessment of that also.
Thank you, Senator. Deputy Terry Stanigan, 2 minutes.
Thanks, Catherlock. 2 questions there for Ms. Schwepp. Yesterday, the committee, we had extensive hearings and evidence from the masters of the large hospitals, maternity hospitals, who said they didn't feel restricted in offering all necessary medical assistance to mother in a medical emergency situation during pregnancy. And they've personally unaware and haven't seen examples where the current law and the practice in Ireland had restricted all necessary care to a woman. So just to ask, if this is the case, why do we need to change the law from the current practice on medical matters? You say that mother and baby as well are loaded terms, and that was brought up by a previous speaker. But in fact, it's the European Court of Human Rights regularly uses mother and third child as the terms. Just to ask you, do you believe that the unborn child is entitled to any rights at all? Regarding Ms. Staunton, there I have a question that you wrote in the paper where the health and the well-being of the mother is at risk and she is not in a position to voluntarily travel abroad for abortion. She has no option but to do so. It would seem to be there, obviously, that you're advocating a lower test for the introduction of abortion. So just to comment on that, is that's your personal view. For Mr. Mills there, is there any duty of care in your bill towards the unborn? Do you believe that the unborn baby who has a fetal abnormality enjoys absolutely no constitutional protection? And just to ask as well, has there ever been a conviction in Ireland under section 59 or 60 of the 1861 Non-Fatal Act?
Thank you, Deputy Senator Jim Walsh. 2 minutes, Senator.
Chairman, yesterday I think we had a good consensus from the medical people that current medical practice is very good, if only it could be some way statutorily underpinned. Issue is the area of suicide, and despite what you're saying to us, clear evidence yesterday from the professionals in the field was that it's not easy to predict. It's very difficult, in fact. And indeed, we also have seen psychiatrists on the pro-life and on the pro-choice advocacy side over the period of all these debates. One of the psychiatrists yesterday actually said in evidence that if a woman presented claiming to be suicide, she would believe her. We also heard evidence that in Britain a survey has been done which showed that there's 97% of predictions are in fact false positives. That's backed up. Now, when I have that, and I also look to see that the architect of abortion in Britain, Lord David Steele, recently said, it would seem the mistake being made in Ireland is to try to define the circumstances in which each abortion may be carried out, and that is a hopeless road to travel down. I never envisaged there would be so many abortions. In Britain, 6.4 million abortions since 1968 up to 2011. 150 were to save the life of the mother. Those are British government figures. Could I just also say to Ms. Schwepp, you mentioned about language, but the actual European Court of Human Rights regularly uses the phrase mother as a synonym for pregnant woman, and her child as a synonym for fetus. So I'd ask you maybe just to reflect on that. And finally, can I just ask, in relation to fetal abnormality, and very briefly on this, I'm unclear. I understand the fetal abnormality situation, which, you know, we've had people into the House. I can understand that aspect. But from what you're saying, I'm detecting, particularly from Mr. Mills, and to an extent from yourself, and I'd just like to clarify whether I'm right or wrong, that you may well be seeking that unviable fetuses. In other words, that you're looking for abortion up to 20 to 24 weeks. Am I right or wrong in assuming that that's your position?
Thank you, Senator. Deputy Éanna Riordan, 2 minutes.
Thanks, Chair, and thanks to the witnesses for being here and for the excellent presentations. And I'm particularly interested in the draft bill which Dr. Mills has presented. Just again under Section 9, termination of pregnancy in cases of lethal fetal abnormality. But legislators will be asked to differentiate in a way would be between an unsustainable pregnancy and a pregnancy which may last for moments outside the womb. And in that case, would you suggest that perhaps the constitutional referendum would be necessary in order to clear up that, unfortunate determination that legislators may be faced with? Also, under the conscientious objection clause that you have Part 5 there, Section 13, is this a conscientious objection? Is this a normal practice within legal frameworks to have a conscientious objection? I'm unsure as to that. Thank you.
Thank you. Deputy Timmins and then Deputy Tobin. That'll be the last name because the time is almost up.
Thank you, Chairman. I'd like to congratulate and thank the contributors here this evening or this morning. It's clear to put in a tremendous amount of work on it. And just one question firstly for Ms. Webb. She mentions in her submission that when life begins for the purpose of the Constitution has never been addressed. Just let ask her, does she think that it should be? And if so, how could it be when she has any views on it? With regard to Mr. Mills, if I may use the term, he's just what the doctor ordered. He covers all aspects, the medical, the legal, and more importantly, the medical ethics. And I want to compliment him on his comments about the centrist position in the middle ground and seeking a clearer expression in both the public space and in political forums. It's something that many of us in political life often seek but very seldom achieve. And if it could be achieved, with regard to this and other issues, we would solve them a lot more quickly than we do. I want to commend you for having the courage to actually publish your bill. And in looking at it, just the two sections that I just want to deal with briefly, Section 7 and Section 9. Section 9, the fetal abnormality, it's very clear, it's definite, it's scientific. But then to come back to the Section 7, which is the difficulty for people, and the suicide issue. Now, whether you agree or disagree that suicide should be grounds for termination, let's take it that you do agree. The difficulty in Section 7, based on the evidence of psychiatrists yesterday, where one would say that abortion isn't grounds for termination, can never be, and the other will disagree. How do you see that actually working out in practice? If it is permitted that this is part of the bill, we have a situation where someone that's seeking termination on this grounds, that they would go to, that it would become known fairly quickly what psychiatrists would give the positive answer and which would give the negative. How do you actually deal with that when it's, according to the psychiatrists themselves, an inexact science? One final brief point, Chairman, and it's probably outside the remit, and if the members don't want to answer, the Chairman doesn't want to permit it, I appreciate that. But in the context of claims that might be made later on in the day by the other contributors, the concept of the Supreme Court decision, the intention of the election versus the decision of the Supreme Court, and Ms Staunton mentioned about the 12th to 25th amendments were voted on the suicide issue. An argument has been put forward and will be put forward that it wasn't strictly just about the suicide issue. The people who voted no on that occasion, many would be opposed to the concept of suicide being grounds for termination. So if you have a view on that, but if the chairman disallows that, I'm quite happy.
Thank you. Deputy Tobin, finally.
Gurmia Margaret, and I hope you can hear me despite my cold here this morning. The Supreme Court stated that there must be a real and substantial threat to the life of the mother. Is there any quantification of what a real and substantial threat has to be in order to achieve a particular termination? Because we heard from the Master of the National Maternity Hospital yesterday that medicine and treatment is on the basis of probabilities. And we also heard from psychiatrists yesterday that typically 3% of, diagnosis with regard to suicide actually end up in suicide. So would a 3% confidence level or of identification of actual suicide be a confidence interval or confidence level enough for a real and substantial threat to the mother's life to be taken into account?
Thank you, Deputy. Okay, we have 11 minutes in the session remaining, so I'll ask maybe Ms Schwepp to start and then Ms Staunton and Dr Mills.
Thank you for all your questions. Senator Batchik, whether we should have different legislation for emergency and non-emergency situations, I think your argument is quite compelling on that. I suppose when we look to legislative change, we often look to our neighbours, not our nearest neighbours, but our next nearest neighbours in England and Wales. And I suppose that's the sort of framework that I was thinking about when we're talking about legislation for this issue. Deputy Flanagan, in the same way that some doctors didn't feel restricted by the current legislation, other doctors did. And I think that the fact that there is a difference there needs to be addressed. Do I believe the unborn child is entitled to any rights? I respect the constitutional position that the unborn has a right to life. Senator Deputy Walsh, again in relation to that issue of language, I think that we should use constitutional language, certainly in relation to fetal life, that is to use the term unborn, and I think the term pregnant woman doesn't have any emotive or moral or ethical undertones. In relation to viability in 20 to 24 weeks, generally fetal abnormalities are picked up at an early stage of the pregnancy. Fetal abnormality scans are generally take place at around 18 weeks, so I think that any issue would be brought up before that stage. Deputy Timmins, I hope I say in my submission that the issue of when life begins has been addressed, that the issue when unborn life ends hasn't. And so I think just to clarify that. And finally, Deputy Tobin, doctors make assessments in relation to risks and benefits of medical treatment every day. It's what they do for a living, and we trust them to make those assessments as to what risks and benefits are associated with treatment. And I think that we need to simply apply what they do every day in this very narrow context of medical treatment.
Thank you. Ms Staunton.
Okay, I'll start from the last. Deputy Tobin, what is a real and substantial risk? I think we've addressed this numerous times. It's up to the doctors. We have to trust their opinion. It's probably on the matter of probability. There is a real and substantial risk to the life of the woman at some point during the pregnancy. That is what is a real and substantial risk. Like Ms Schwepp said, they do make these decisions all the time. They don't really deal in percentages, and they base it on their clinical judgment and their experience. I think we have to trust and respect their decision. Deputy Timmins, when you talk about suicide, whether we should have it in or not, that discussion is actually irrelevant. That is the law. If a woman is suicidal due to her pregnancy, she's entitled to abortion. So whether or not we put it in is actually not debatable. We have to include it. The 12th Amendment, we deal with the 12th and 25th Amendment. I'll deal with the 12th first. The 12th was solely on suicide, and that was rejected, very clearly rejected. And the other two amendments passed. So the people very clearly said they were happy with the Travel and Information Amendment, but they were not happy with the suicide. Coming to the 25th Amendment, there has been a lot of academic commentary on whether or not or why this was refused. Again, it's irrelevant. The 25th Amendment was rejected. Suicide was a part of that. And the people rejected, which again reinforced their statement on the 12th Amendment. Deputy Walsh, regarding suicide, again, I echo what I said. It's irrelevant. We have to include the threat of suicide. When you're discussing about the UK, we have a very, very different regime. We are talking about a very, very narrow test. The UK is completely different, and we should not look to what has happened in the UK. We are talking about where there is a real and substantial risk to the life of the woman. That is not abortion on demand, and should never, ever, ever be seen on abortion on demand. The only time in which an abortion is lawful in this jurisdiction is when there is a real and substantial risk to the life of the mother, and I really cannot overstate that. Deputy Flanagan, regarding language, mother and child, our constitution states unborn. I think we should follow our constitution and what it actually says in that terminology. I didn't actually hear your question in relation to my submission. There was a lot of movement, so if you want to repeat that, I'd be quite happy to answer.
Just for personal view, I suppose, in relation to the current situation. Sorry. Just basically, you seem to be advocating a lower test, abortion test. I'm just wondering your personal view.
Where in my submission did I indicate that?
No, it was just in a paper. I quoted from a paper there that you had said about the health and well-being of the mother is at risk, and she's not in a position to voluntarily travel abroad for an abortion. She has no option but to do so.
Is that an article I published?
It was, yeah.
That is completely different. I was discussing the ABC decision and also my own personal opinion. I was called here to give evidence as a legal expert on the X case and the implementation of the X case. I am therefore advocating a test in accordance with the X case and our constitution. What I have written outside of this submission is not actually that irrelevant to what I'm actually saying here.
Dr. Mills?
Echo what Ms Staunton says about this is a place for our dispassionate.
Sorry.
This is a place for us, insofar as is possible, our dispassionate legal opinion, and I hope that we've furnished that just to deal with the matters that were raised by the various deputies and senators. First of all, Senator Batchik. I find myself in agreement both with her and with the contrary position that has been presented. There may well be circumstances in which a bill that envisages, such as the bill I've presented to you does, a two-doctor system may require deviation in certain circumstances, either in favour of a single doctor opinion, which, as I think I said it in reply to Senator Crown, which may involve, for example, the making of regulations and the explanation of why, in the circumstances of the case, only a single opinion was furnished. And there may also be, and this is why the bill, for example, provides with language of no fewer than two doctors, there may be circumstances in which, in order to get a properly circumspect view of the totality of an individual pregnant woman's care, more than two opinions may well be required. And I certainly don't exclude that possibility in the bill that I've prepared. Deputy Flanagan referred yesterday to doctors not feeling restricted by the current situation and asked you and us to infer that there was no requirement for legislation. He must have been listening to different hearings to the ones I was listening to, because I heard a doctor say, I don't want to go to jail. It's hard to imagine any more restriction on a doctor than a fear of losing his or her liberty. I also heard a doctor say that I need clarity on this. I also heard another doctor say, I need clarity on this. And I think I heard another doctor say, I need clarity on this. I think I heard the medical council say, I need clarity on this. And I'm pretty sure I've heard the legislature say, we need clarity and legislation on this. There is a chance that at whatever inquiries Deputy Flanagan was at yesterday, what he contends for was said. But it wasn't said at this inquiry, and it hasn't been said anywhere in the sphere of public discourse. He did ask me two specific questions, which is, do doctors owe the embryo a duty of care, or the fetus a duty of care, or the unborn child a duty of care? Yes, of course they do. Any obstetrician will tell you, any general practitioner involved in the care of a pregnant woman will tell you that in the generality of matters, they have two patients in front of them. And I don't demur from that point of view, insofar as it is held by doctors. The other question was asked, do I believe that the lethal that a fetus or an embryo with lethal fetal abnormality has any rights. I think that the termination of a pregnancy is always a morally serious decision. But what I know is that the Supreme Court has told lawyers everywhere in this jurisdiction and legislators everywhere in this jurisdiction that the born alive test is an essential index of the right to life as comported by the Constitution. Ironically enough, Senator Walsh, in his opening remarks, talked about the need for legislation, thus suggesting that he was at the inquiries I watched yesterday, as opposed to the inquiries that Deputy Flanagan was watching yesterday. And he talked about quotes from Lord Steele, and Lord Steele's concerns about the Act and the consequences of the Act introduced there. But there's a very simple solution to that with the greatest of respect. Don't introduce the 1967 Act here. Introduce something different, introduce something with safeguards, and introduce something that is consistent with Article 43.3 and consistent with the needs of pregnant women. In relation to two questions that were posed in relation to the draft bill by Deputy O'Riordan, the first is what about lethal fetal abnormality? Well, I say as drafted, the bill is consistent with Article 43.3, and it is consistent with Article 43.3 as interpreted by the Supreme Court. I was also asked about the question of conscientious objection, and is it unusual to include conscientious objection in a bill? Yes, it is. But this is a sui generis, one-of-a-kind legal, social and political matter in relation to which Irish people have very strong feelings, not uniquely strong feelings. And I'd simply observe that for all of the criticism of the 1967 Act and the regime introduced underneath by it, it also includes a role for conscientious objection. And I think that that is one aspect of the 1967 Act that we should import. I agree with Ms Schwepp and Ms Staunton on the question of psychiatry, and in relation to Deputy Tobin's questions about psychiatry, I would just ask him to sit down and read the testimony given yesterday by Dr McCarthy.
As the time allocated has elapsed. Sorry. Our time allocated is 3 minutes is up. I'm going to ask Ms Staunton to give a 3-minute final summation, then Ms Schwepp and then Dr Mills. Thank you.
I once again would like to thank the committee for inviting us here to give our independent legal opinion on the X case and the implementation of that. First of all, when this committee begins to draft the heads of the bill, I think the most important thing we do is give effect to the X case. We must ensure that the legislation states when an abortion is lawful in Ireland in accordance with the X case. However, I really would urge you to consider the other issues and the other situations which may arise from Article 43.3. We do not want to come back here again if we can prevent that. The second issue is that the legislation must be prescriptive to a degree to ensure that doctors have certainty as much as they can as to when an abortion is lawful in Ireland. However, the legislation must give effect to the fact that doctors are making hard choices. These are a very small number of cases, and the cases and decisions are going to be hard. So you must trust the clinical decisions of our doctors to act in the best interest of both the pregnant woman and the unborn child in accordance with the legislation and Article 43.3. Finally, I just want to reiterate that there should be no floodgates. Suicide is not a catch-all for women who want abortion on demand. A woman is only entitled to an abortion if there's a real and substantial risk to her life, which includes a threat of suicide, and it's only if that suicide is directly linked to her pregnancy. If she's suicidal prior to the pregnancy or just suicidal in general, she will not be entitled to an abortion. It is only when that is very directly linked. Thank you.
Thank you.
Thank you again to the committee and the chairperson for an opportunity to express my views on the current legal situation as I see it. There's just 3 quick things that I want to reiterate in my final summation. First is what we're doing at the moment is legislating for the law. We're legislating for the current legal situation. There is no question to answer in relation to whether suicide should justify the termination of a pregnancy where that suicide, as Ms Staunton said, is linked to the pregnancy. To question its justification is to stigmatise mental health and to diminish our respect for medical practitioners who work in this incredibly difficult area every day. The second issue is in relation to fatal fetal abnormality. I believe that the law as it currently stands is that unviable fetal life is not life for the purposes of Article 43.3, and that in the legislation a declaratory section should be included to that effect. Where the life is viable, I think that a constitutional referendum would be required in order to allow for termination in those circumstances. There is no requirement of certainty in either the X-case test nor the viability issue. It needs to be established only as a matter of probability. There is no requirement of 99%, 80%, 60%. It simply needs to be established as a matter of probability in accordance with the views of the relevant medical practitioners. Finally, I would also echo Ms Staunton's recommendation that we use this as an opportunity to be proactive rather than reactive in relation to this issue as a whole. Academics and the courts have come up with scenarios where we're still not entirely clear on what the law is, and we have spent huge amounts of money commissioning reports which have simply been ignored. The Commission on Assisted Human Reproduction would be the most obvious one, which requires immediate incorporation. There are still some straggling issues in relation to travel and information which need to be addressed. For example, can the husband of a pregnant woman be entitled to know that his partner is seeking to travel to terminate her pregnancy or is seeking information in relation to that pregnancy? Do asylum seekers have a right to leave this jurisdiction to terminate a pregnancy in circumstances which would not be constitutional? I've already talked about the issue in relation to consent for those individuals who, by reason of age or capacity, require proxy consent to be made for them. In certain circumstances, this will be made by a guardian. In other circumstances, it will be made either by the District Court or the High Court. And the question as to whether the High Court can allow an individual to travel to terminate a pregnancy in circumstances which are unconstitutional, Mr Justice Gagan said should not be allowed, and I think that that issue requires clarification. And finally, the issue of third-party fetal assault remains entirely open in this jurisdiction, and I think that it's not terribly complicated to legislate for this, but I think that it needs to be included in the bill. So thanks once again for your attention.
And finally, Dr Mills, and just before you come in, I think in fairness to Deputy Flanagan, he is genuine in his commitment and his commentary and his participation in the hearings, and he wasn't being derogatory about anything you said, so just in case you think he was, in your reply, I think you were maybe a bit sarcastic with him, but just, in fairness, he was.
To be fair, Chairperson, I think I was more than a bit sarcastic, but I am happy to concur with the rules of this House, and if anything I said was interpreted as sarcasm or rudeness, I apologise that if any offence was caused to anybody listening to those remarks. It also occurs to me that there is one question I didn't answer, and I just very quickly, I don't want to be accused of having ducked or not answered any questions. It was a question put to me by Deputy Naughton, who asked whether, when I worked as a general practitioner, had I ever seen a suicidal pregnant woman. The answer to that question is yes. I do recall seeing women who were pregnant and who were suicidal, but the question of whether they were suicidal within the meaning of the X case was not a matter for my clinical judgment, and so I cannot answer the question with any more precision than to say that I did attend at various times depressed and indeed suicidal pregnant women during my time as a general practitioner. I think it's worth the committee perhaps observing that Ms Repp and Ms Staunton and I have all worked entirely independently on these matters, save for the fact that I took the liberty, because I had her email address, of furnishing Ms Schwepp with a copy of the draft bill yesterday. I had no idea what she was going to say. I had no idea what Ms Staunton was going to say. They had no idea what I was going to say, and certainly no idea what the contents of the bill would be. And I think it is interesting and informative that there's a coherence and a coalescence of our views, and that, as a matter of fact, the bill that I have presented for you articulates the vast majority of the views that have been so cogently expressed by Ms Schwepp and by Ms Staunton. And I think that is something that the committee, I think, should have some account to when considering the evidence that you've heard today. I think it's just an interesting coalescence of views. I just want to say one last thing in relation to the bill that I've commended to you as the basis for a starting point of talking about this more and about the form final bill would take. And I say it in the light of what I heard said yesterday. The bill I presented to you deals with a number of things that were raised. It deals with clarity, which was called for by Dr. O'Mahony from the National Maternity Hospital. It deals with the requirement for specialist doctors, which was called for by Kieran Murphy of the Irish Medical Council. It deals with the question of conscientious objection, which was called for by Dr. Mary McCaffrey. It deals with the fear of floodgates, which was called for, which was